Hello everyone, I am Yashveen Khan and today we are discussing the case laws on contract law. The case we have is Hyde versus Wrench. In this case, the defendant Mr. Wrench offered to sell the farm he owned to complainant Mr. Hyde. He proposed to sell the house for $1,200 but Mr. Hyde rejected this offer. The defendant decided to write the complaint again with an offer to sell the farm to him at $1,000 this time. He was very clear that this was his final offer for the property. In response, Mr. Hyde made a letter of offer $950. Mr. Wrench rejected this and confirmed it with the complaint. Mr. Hyde subsequently decided to accept the previous offer of $1,000 to purchase the farm, but Mr. Wrench refused to sell his farm this time. So Mr. Hyde filed a suit against him pleading for a specific performance of the contract, which arose in this case were whether the parties had a valid contract or not, and if a counter offer was made in discussion, whether the original offer would still be valid or not. The judges in this case rejected the claims and held that Mr. Hyde and Mr. Wrench had not entered into a legally enforceable agreement about the property. The previous offer was superseded and wiped out when a counter offer is made. The initial proposal is no longer available. The next case is Harvey versus Facey. In this case, Harvey, who is in charge at the Jamaican partnership firm, wanted to purchase the property owned by Facey, who was also negotiating for it with Mayor and Council of Kingston City. In order to prevent the property from being sold to Kingston City, the appellant sent telegram about acquisition to Mr. Facey on October 6, 1893, who was travelling at the train at that time. Telegram said, "Will you sell us the bumper hall pen?" Telegraph lowest cash price, answer paid. The lowest pricing for a bumper hall pen is £900 in response to Mr. Facey. Mr. Harvey responded in turn saying, "We agree to purchase bumper hall pen for £900 you have asked. Send us your title deed as soon as possible so we can take ownership right away." Then Mr. Facey had a change of mind and refused to sell the property Mr. Harvey. Mr. Harvey filed a lawsuit against Mr. Facey asserting that they had a contract and said that the telegram was an offer and he accepted it. The issue which arose in this case was whether the contract was valid or not. The judges in this case held that the parties have never had a contract. The initial conversation does not constitute an offer that could be accepted. It was merely a request for information. As a result, the telegram by Mr. Facey was not credible. It was determined that Mr. Facey's telegram is just a piece of information. Facey never presented a proposal that could be accepted. Next case we have is Hadley versus Baxendale. In this case, a steam driven mill owned by the plaintiff has a fractured crankshaft. The broken piece had to be transported from Gloucester in the west of England to Greenwich, close to London, where it would be used as a model to create a replacement piece. Due to plaintiff's lack of replacement piece and the fact that engine was out of order, the piece needed to be delivered as soon as possible. The plaintiff filed a claim for lost profits on the Pickfords, the shipping company, who was delayed in delivering the part. The issue which arose in this case was whether the plaintiff was entitled to damage for the lost profit and defendant liable for breach of contract or not. The judges in this case ruled in favor of the defendant, holding that a party could only successfully sue for the losses brought on by a breach of contract if the loss is reasonably viewed to have resulted naturally from the breach, or if the possibility that such loss would occur should have been reasonably anticipated by the parties at the time of contract was formed. Baxendale was not responsible for Mill's lost profits because he had not responsibly foreseen them and Hadley had not informed him of their possibility. The next case law we have is Felthouse versus Bindley. In this case, Felthouse negotiated with nephew to buy a horse. A pricing discrepancy occurred because uncle offered less than nephew wanted. The nephew received a definite offer from uncle in January, but neither a response nor any action was taken because horse remained in nephew's possession. In spite of nephew's instructions that the horse be reserved, the horse was sold in an auction in which nephew sold all of his farm stock in February. To reclaim the horse, Felthouse filed a lawsuit against auctioneer Bindley. The issue which arose in this case were whether the plaintiff and defendant had a valid contract or not, whether a response of silence or rejection is regarded as acceptance or not. The judges in this case decided that because there was no contract that was intended to be accepted, Paul Felthouse had no ownership rights to the horse from the beginning. It is the responsibility of accepting party to inform the offerer of their acceptance. An acceptance of offer cannot be inferred from silence alone. The acceptance communication was finished on February 27th, the first date, but auction had already happened on February 25th, proving that Felthouse had no interest in buying the property. The next case we have is Durga Prasad versus Baldev. In this case, the complainant demanded that the district collector establish a number of outlets in his neighborhood. The defendant paid rent to those establishments in the exchange for their business. At the same time, the rent was affixed. Later, the defendant informed the plaintiff in return for the plaintiff's construction of the building through the expenditure of vast sum of money, he would pay him a 5% commission on all goods that he will supply from the shop. On the other side, the claimant chose not to pay the commission. Durga Prasad thereafter filed a lawsuit against the shop owners who had denied to pay the commission. Issues which arose in this case were whether the contract is valid or not and whether the contract is enforceable by law or not. The judges in this case dismissed the case after finding no merit in the claims of plaintiff. The decision was made in the light of the absence of a prominent and recognized consideration in this situation, which led Section 2D of the Indian Contract Act 1872 to reject the eligibility of agreement for recognition as a contract. Section 25 of the Act states that absence of consideration resulted in the contract being termed as a void contract. So that's all for today. Thank you.